Talking about a speaker for tonight, Ms. Shruti Rajagopalan is an assistant professor of economics at State University of New York, Curtis College, and a fellow at the Classical Legal Institute of NYU Switzerland. She earned her PhD in economics in 2015 from Georgetown University. Shruti's broad areas of interest is the economic analysis of comparative legal and political systems. Her research interests specifically include law and economics, public risk theory, and constitutional economics. Her research has been published in peer-reviewed journals, law reviews, and books. She also enjoys writing in the popular press and has published a series of editorials on the Indian political economy in the New York Times, the Wall Street Journal, the Hindu Business Line, and the Indian Express. Ms. Shruti, we are extremely glad to have you amongst us. Ladies and gentlemen, Ms. Shruti Rajagopalan.
Hi, I'm Shruti Rajagopalan. Hi, I'm Shruti Rajagopalan, and I'm very happy to do this with SFL. This is my first webinar with SFL, and I'm quite excited to do this. As Shri mentioned, today I'm going to talk to you about Bhopal gas tragedy, and I'm going to quickly switch to my PowerPoint, and I hope you can all see it. The title of the talk today, as you know, is called The Other Tragedies of the Bhopal Gas Leak. And as many of you may know and may have read in the newspaper, today is the 31st anniversary of the gas leak that happened on in the middle of the night between December 2nd and December 3rd in 1984. Now, what has really happened in Bhopal since has been a long tragedy of victims not getting compensated, and a lot of other medical problems and environmental problems developing because of the gas leak. And we're going to analyze some of those today. At the beginning of this webinar, I just want to make it clear that most of the analysis that I have done in my paper, which I'm going to talk about today, and in this presentation is really an economic analysis of the case. It's not any kind of like a specifically ideological analysis. So in other words, it's not normative. It's a positive analysis of the Bhopal gas leak. If you have any questions or clarifications while I'm speaking, please let me know and I'll answer your questions. But otherwise, I've reserved about 20 to 30 minutes in the end just to have an open discussion with all of you and to answer all of your questions. So just to begin, these are some pictures that were taken by the famous photographer Raghu Rai just immediately after the gas leak. And this is what the industrial and chemical plant looked like. As you can see, amidst all the fog, the Union Carbide plant was right in the middle of the city, very heavily populated, and you can see lots and lots of homes and small like hamlets and slums right next to the area of the plant. As I mentioned, on the midnight of December 2nd, the highly toxic gas, which predominantly was methyl isocyanide, leaked from the Union Carbide plant in Bhopal. Union Carbide India Limited, which was the actual plant in Bhopal, was a subsidiary of the Union Carbide Corporation, which was an American company at the time. Now it's owned by Dow, the ownership changed much after the Bhopal gas case. On the morning of December 3rd, immediately after the gas leak, methyl isocyanide is such a toxic gas that it kills almost immediately. So there were at least 2660 deaths and about 200,000 people suffering varying degrees of injuries, permanent, temporary, mild injuries. So pretty much anyone who came into contact with methyl isocyanide was affected in some way. Some died immediately. The rest of the effect, the real effect of the nature of the injuries and how long-term these injuries were would only reveal themselves over the next few decades. But you can see that there were mass burials and mass grave sites in the first 2 weeks following the Bhopal gas leak. I will say, however, in hindsight, now that we're 31 years after the gas leak and the industrial accident itself is now quite far in our memory, to me the real tragedy today is that even after 31 years we don't have an accurate count of the victims, and most of the victims that we do know are genuine victims have still not received legal compensation or medical care. This is a picture of the Bhopal gas victims and their widows protesting right outside Jantar Mantar. And this was when President Obama visited India. They were still fighting for compensation. This is pretty recent. And they were still fighting for extradition of the then chairman of Union Carbide Corporation, who has since died. So even today, if you go to any of the popular protest sites in New Delhi on the anniversary of Bhopal, or even through the year, you will see a large number of victims and their families still protesting not the original industrial accident, but the fact that they've not yet received compensation, which is really quite extraordinary that it has taken us 31 years. If you look at the sign that they're holding, for those of you who can't read Hindi, it says Sahi Aakde Sahi Muavza Dena Hoga, which means we need to know the right numbers and the right amount of compensation, and it must be given to the victims. So as you can see, they are not really protesting for anything big. This protest is not about the big environmental concerns. They're not protesting against foreign presence of corporations. They're not protesting against Union Carbide itself. Their simple request, which is quite legitimate after an accident of this scale, is only that they need to be recognized as victims and they need to be given the compensation that is owed to them that was judicially determined. The fact that this is a failure and this has not yet happened, I would say is a huge failure on part of Indian state and Indian society, that these victims have just been left in the lurch. So one of the things that happened, if we just go back to the previous slide, one of the things that happened immediately after the Bhopal gas leak is, as I pointed out, Union Carbide Corporation was an American firm. And this news made it across the world, and it was the headline in the New York Times the next day. And what happened was, in the first 2 months after the gas leak, they realized that there were a lot of victims and had various very severe injuries. And American lawyers started filing claims on behalf of the Indian victims against Union Carbide Corporation in the United States. So I'm just going to break that up for you. So American lawyers, who were typically injury lawyers, personal injury lawyers, or as we call them, ambulance chasers, wanted to represent the Indian victims. So they flew to India, and immediately after they flew to India, they got all kinds of signatures from and entered into contracts with the victims. And then they went back to the United States and started filing claims in various different jurisdictions that where Union Carbide Corporation was present. And the hope was that they would fight the legal battle out in the American courts using American lawyers. So what really followed the tragedy was what Mark Galanter, who's a famous American jurist who has studied the Bhopal case in great detail, he said what followed was the great ambulance chase. So as you can see in this picture, we have ambulance chasers. They are called so because they are personal injury lawyers. And they're called ambulance chasers because as soon as somebody gets hurt, the lawyers are literally chasing the ambulance to find the victim so that they can sue on behalf of the victims. The lawyers representing the Bhopal victims filed their claim, about 150 different claims, which, when we added up the damages that were claimed in these cases, amounted to $50 billion in 1984. So it's quite a large sum of money. If you look at the dictionary meaning of an ambulance chaser, it's a lawyer who seeks to encourage and profit from lawsuits of accident victims, right? Or it's a lawyer who incites accident victims to sue for damages. So it's a very disparaging or a pejorative term in the legal industry to be called an ambulance chaser, because it means you're trying to make money off of other people's misery and misfortune and accidents, and they're literally waiting for someone to have an accident and become a victim to then go and sue on their behalf and get compensation, and the accident lawyers get to keep a small percentage, usually anywhere between 10 to 33% of the compensation that they get for the victims. Many of you, I don't know if you're familiar with Urban Dictionary, but I teach undergraduate students, and whenever I'm in doubt, I always go and look up the Urban Dictionary meaning to know what students these days are thinking. And when I looked up the Urban Dictionary meaning of the ambulance chasers, it's quite funny. It says a type of lawyer who ranks lower than a pile of excrement in terms of what he or she contributes to society. A mental disease infecting lawyers, attorneys, and others in the legal profession. Symptoms include hurrying to disaster sites to offer legal assistance and advertising heavily on television commercials, often using self-degrading nicknames such as the strong arm. So you can see that no one seems to have a very good impression of ambulance chasers, not scholars like Mark Galanter, who talked about the great ambulance chase in Bhopal, and not any kind of popular culture in the United States. So ambulance chasers are considered very profit-seeking and extremely self-interested, only interested in getting a share of the compensation sort of lawyers. It's not really about justice or anything else for them. So you can imagine that as soon as we had the great ambulance chase in Bhopal, there was suddenly a lot of chatter and a lot of fear amongst Indian politicians, Indian intellectuals, and also Indian civil society, who said that they were very worried that American lawyers are entering into all kinds of contracts with Indian victims, and the Indian victims won't get the full compensation because the American lawyers are going to keep 1/3 to 1/2 of the compensation. So let's say Union Carbide gets sued for $100 on behalf of one victim, and as soon as they get the $100, 33% would go in legal fees. So only $66 would come to the victim. So a lot of people were very worried that the entire amount won't go to the victim, so we should in some way get rid of these American lawyers. They were really trying to profit from Indian victims. And this was being done in a very, like the American lawyers were not very subtle about it, and there was a lot of concern from all quarters. So it wasn't just the government, it was a lot of people who were very concerned. So what the government did to alleviate this concern is they passed a law. First they passed an ordinance, and then a few weeks later it became legislation called the Bhopal Gas Leak Disaster Act of 1985. This was passed in March 1985. The Bhopal Gas Leak Disaster Act tried to do many things, but the most important reason for it was it made the government of India the sole plaintiff of all victims in all matters relating to the gas leak. What that means is that none of the victims could be represented by any lawyer, could not be represented by themselves or any lawyer that they hire, whether the lawyer is within India or outside India. In any court of law where the matter was to be settled, only the government of India, which means the Attorney General of India, could represent the victims of the gas leak, right? The second thing that the Bhopal Gas Leak Disaster Act did was it set up a new commission to deal with welfare, to deal with the welfare of the Bhopal gas victims and also deal with the compensation. And the head of that commission was called the Welfare Commissioner. had many assistant welfare commissioners, etc. So the Bhopal Gas Leak Disaster Act gave us the entire structure of that new commission which was to be set up. And that commission was to deal with all the details of the gas leak and hand out all the compensation. So the structure was as follows. The structure was the Attorney General of India and his representatives would go to the court of law, fight against the lawyers of Union Carbide, and once they got whatever compensation that they got from Union Carbide, they would bring that back to India. They would give that money to the Welfare Commission of the Bhopal Gas Leak, and the Welfare Commission of the Bhopal Gas Leak would start looking at which claims were real and which were the severe claims, like, you know, you would get different amounts if you died versus if your family died, or if you had a permanent injury or a temporary injury, and then they would hand out the compensation to the victims. So this was the two-step process that the Bhopal Gas Leak Disaster Act set up. And the entire intention behind it was American lawyers are not going to care about the well-being of Indian gas victims. So what we need is the Indian government, which clearly cares about its citizens, especially the Bhopal gas leak victims. They should fight for compensation. They won't get 33% of the fees that they keep, so all the money would end up going to the victims. And then what can be better than a paternalist organization like the Welfare Commissioner of the Bhopal Gas Leak Act to distribute that amount? So clearly all this problem was caused by profit-seeking private firms and private lawyers. We will resolve this matter by eliminating all of them from the picture, and this will be a completely government-run situation after the disaster. So the consequences of the act were threefold. First of all, it eliminated the representation of victims by ambulance chasers. Only the government of India could represent them. Second, it replaced the adversarial system of litigation with an inquisition. What we mean by that is, when any of you, if you've seen any movies where there are courtroom scenes, you see that there is a lawyer for the plaintiff and a lawyer for the defendant, and they make arguments against each other, right? So they're adversaries. So it's called the adversarial system of litigation, where they present different arguments from opposing sides, and the judge will decide as the final arbiter who wins the case. In an inquisitorial system, or an inquisition on the other hand, there is no two sides. The judge or the person who is leading the inquisition will find out. They will kind of go on a search mission, and they will find out what the truth is or what the correct information is. So in this case, instead of having an adversarial system of litigation to figure out who the victims were and how much compensation they deserved, once the money was gotten by Government of India, the Welfare Commissioner would decide who to give the money to. So he or she would set out on an inquisition, figure out who the correct victims were, how much compensation they deserved, and then hand it out to them. Finally, the person who was supposed to be the Welfare Commissioner was a bureaucrat. It was set up completely under the Bhopal Gas Leak Act. He was sort of the head bureaucrat with lots of assistant bureaucrats who were supposed to aid in this inquisition or this quest for the correct number of compensation and the correct number of victims. Do any of you have any questions at this point on the structure of the system?
In case you have questions, please raise your hand at this point of time. You're all muted, yeah, but you can raise your hands.
Yeah, if you have any clarification or question at this point. Okay, I guess I'll just go on. So what happened was, this is in 1985. There were a number of things that happened which we can discuss in the Q&A section. Number of things happened in the courts of the United States. So the 150 claims in different courts in the United States were solidified into one big claim, which was in Judge Keenan's court in New York District. And Government of India was represented there, and Government of India said, we should have this case, the legal proceedings of this case in the United States, because the Indian legal system is very slow and is not equipped to deal with this kind of class action tort law, or this kind of class action mass accident case. And Union Carbide, on the other hand, said that this is very ironic, because Union Carbide said that the Indian system is great and the case should be fought in India and not in the United States. And the main argument that Union Carbide made was that the victims would find it very difficult to be represented in the United States. So all this happened in the US, and finally Judge Keenan's court said that the case has to be moved to India, and that the government of India will still be the lead counsel post the Bhopal Gas Leak Act, and whatever legal proceedings were to take place in India. So the forum got changed to India. The second thing that Judge Keenan did was he announced a certain amount of interim compensation, which was to be given. This was already determined in a Bhopal district court, and it was 350 crores. And it was to be released immediately, even before the case was completed. This amount was to be released by Union Carbide, and it had to be given to the most critical and severe cases, and that money was to be used to build shelters for victims, build a hospital, so on and so forth. The case moved from the United States to India, and then from the District Court of Bhopal to the High Court, and eventually to the Supreme Court. While the case was going on, Government of India and Union Carbide reached a settlement. The settlement was reached in 1989, and they negotiated a settlement of 7.5 billion rupees, which is 750 crores. This is in 1989. It's a fairly large sum of money. It was 470 billion in US dollars. The final settlement was based on the assumption that there were 3,000 fatalities and 52,000 victims with different degrees of injuries. So they'd come up with some kind of a chart and said, for so many fatalities, we're going to pay so much money. Out of the 52,000, there were, let's say, 10,000 very severely injured victims, so they get the most compensation, and then there are less severely injured victims. And then there's also money set aside for things like loss of cattle, loss of livelihood, loss of any kind of home or shelter that they were living in, so on and so forth. The most unique thing about this settlement, and this is unique in the context of this type of case, the most unique thing was it completely absolved or relieved Union Carbide and Union Carbide Corp India Limited of all past, present, and future liability. So typically, when you have a gas leak or an environmental leak or something like Chernobyl, or if you guys have seen movies like Erin Brockovich, which is about a certain type of poisoning from an industrial chemical plant, which leads to a lot of medical problems like cancer and long-term effects in children, you see that they never get absolved of future liability. Any settlement that you reach is only about past liability and maybe present, but typically in these kind of accident cases, because you don't know the full extent of the damage, which will only be revealed in the next 20, 30, 40 years, you never absolve them of future liability. So this last bit on absolving them on future liability was extremely unique. And a lot of people fear some bad faith and some underhand dealings in the negotiations between Union Carbide and Union of India on this particular regard. The second sense was that 7.5 billion rupees or $470 million is too small an amount for an industrial disaster of this magnitude. But nevertheless, this was the settlement that was reached between the two parties, and the Supreme Court signed off on the settlement, and that amount was deposited in a bank account in RBI. And the hope was, now that they have the money on 14th February 1989, which was 26 years ago, that over the next few years, all this money will be dispersed to the various victims who deserved compensation. Now, what actually happened? Like I said, all these numbers were based on 3,000 fatalities and 52,000 victims. What really happened was the number of deaths, which was reported in newspapers and things like that on December 2nd, 3rd, was 2660 deaths and 200,000 injuries. The Government of India settlement said there are only 3,000 deaths and 52,000 injuries. if you start digging a little bit deeper, and I'm just laying down a snapshot of the different numbers by different agencies. But there are about, if you really dug deep, you would get about 25 to 30 different contradictory set of numbers. So Dr. Satyarthi, who performed all the autopsies and tagged the victims who came to the hospital, says that within the first 2.5 weeks of the Bhopal gas leak, he and his team personally conducted 10,000 autopsies, which we can assume is a minimum of 10,000 deaths. The Supreme Court, when all of this was challenged in Supreme Court later in 1991, the Supreme Court said, oh, the numbers are wrong, and the settlement was based on 3,000 fatalities and 52,000 injuries, whereas the actual number of fatalities is 4,000 fatalities and 70,000 injuries. Amnesty International, as early as 1984, and this is an independent global organization, said that there are 7,000 to 10,000 fatalities and over 100,000 injuries. Amnesty International revised those numbers between 1985 and in 2003 they said between this period there have been over 15,000 deaths attributable to the Bhopal gas leak and over 100,000 injuries. And in 2014 there was a case filed in the Supreme Court to reopen the question of compensation and the original settlement with Union Carbide, where the government of India, this is the Attorney General of India, has given these numbers. They said that the settlement was reached based on a false count, and the actual number of deaths are 15,000 deaths and 500,000 injuries. So as you can see, we don't have any kind of accurate count of how many people died, how many people were injured, who were the people who died and were injured, and how much money needs to be handed out to them. And this question has been going on up to 2014. So the Government of India case is from last December, which is fairly recent. The money has still not been dispersed to all the victims, so we're still figuring out 31 years later what the accurate count of victims is. If you look at how many people, there's a secondary problem. So one problem is we don't know how many people actually died and actually got injured. The second level of problem is you can't figure this out based on the claims of compensation with the Welfare Commissioner in Bhopal, because over 1 lakh people have filed claims of compensation for injuries for the original settlement which was reached based on 52,000 victims, and over 22,000 claims have been filed for deaths against the original amount of 3,000. So there is a dual problem. The first problem is we don't know how many victims there are. Second, we can't figure out that number based on claims because some of those claims are genuine and some of those claims are totally fake because people are trying to make money off of gaming a government bureaucratic system by trying to get the compensation that is supposed to go to victims, but either those victims have died or they moved out or they don't have good legal representation, so they're not in a position to get compensation, and there are these other people who made all the fake papers, got some documentation signed by doctors, and they are trying to claim compensation for injuries that never happened. What they have done is, so far, 500,000 claims have been settled. Now, once again, I want you guys to go back to this number. The original settlement was based on 300,000 deaths and 52,000 injuries. Now, suddenly, 553,015 claims have been settled, right? That's 5 lakh claims. That's an extraordinary number given what they originally imagined. The compensation that's been given out is about 14 billion rupees. The average compensation that has gone to each person is 25,000 rupees, about $400. So after 20 to 25 years of fighting these cases, you get 25,000 rupees, which is close to 1,000 rupees per year of fighting for compensation. As you can imagine from the extent of the injuries of this kind of an industrial disaster, that can't pay for much. So even the people who have been given compensation have been given such little compensation. It's really a tremendous insult to the victims who've been fighting for justice and just basic things like medical treatment for so long. Do you have any questions at this point on the structure of the way the case proceeded and the way the compensations were given out? Yes, Aishwarya, please go for it. Aishwarya Singh?
Aishwarya, you've just been unmuted. You can speak now.
Okay.
Yeah. Can the legality of the settlement agreement entered by the government and Union Carbide be questioned at this moment? Because there were a lot of costs which it did not take into account.
Yes. Can you just say that again for everyone?
Yeah, like, can the legality of the settlement agreement be questioned at this moment? Because it specifically did not take into a lot of compensation, like future compensation and damages which might collect of the future generations would come up.
Yes. So you're absolutely right. So, you know, the question of whether it can or cannot be questioned, this is a very unique case without much precedent of this kind of an industrial disaster. So the answer is both yes and no, right? I mean, you can open up the can of worms anytime you want as long as the government and the courts are willing to do it. They did challenge the legality of the original Bhopal Gas Claim Act in a case called Charanlal Sahu versus Union of India, where the court said that no, the government of India can represent all the victims. Then the 1989 settlement was again challenged in the Supreme Court in 1991. If you can see the chart that I have up with the 4,000 victims and the 70,000 injuries, this was discussed in the challenge to the case. And what the court said, and specifically, was any shortfall in the compensation because the government got the numbers wrong have to be made up by the government of India. So that question has already partially been resolved in 1991. So the court took a very clear view. They said the government negotiated the settlement with Union Carbide. The government, in all its sovereign power, absolved Union Carbide of all responsibility, right? They did so based on certain assumptions. And if those assumptions have turned out to be incorrect, then what we need to do is we just tell the government that they need to make up the difference. So let's say you have $100 worth of compensation, but you get $150 worth of claims. The $50 gap will be filled up by Government of India, which basically means Indian taxpayers are supposed to make the shortfall. Can that be questioned again? Government of India tried. As you can see in 2014 last year, the Attorney General presented before the Supreme Court. They made a case for reopening the settlement decision with Union Carbide. That hasn't gone anywhere. There's been no hearing after December of 2014. So whether that case is going to go anywhere or whether anything will happen, only time will tell. Does that answer your question, Aishwarya?
Yes. Just a clarification. The settlement agreement was for past and future liabilities regarding deaths and injuries, right? But it did not.
No.
Did it cover environmental damage?
It covered everything. It covered future medical costs, environmental damage, pretty much everything.
Yes. Fine. Thank you.
So there are a couple of things, right? There's environmental damage, which directly. So I'll tell you the kind of things it covered. For instance, if the groundwater in Bhopal is very toxic, okay? Now, children who are being born today in Bhopal, who are drinking that groundwater, are not direct victims of the Bhopal gas tragedy, but they're showing the same medical problems as the original victims of the Bhopal gas tragedy because they're being infected by the same chemicals, right? There is no provision in the original settlement on how to deal with these cases. So one way of thinking about it is when you absolve them of past, present, and future liability, that is completely resolved. Another way of thinking about it is we never covered these specific instances, so maybe they can be reopened. Now, that's a question for a court of law to determine, but the way I would read the original settlement is they were absolved of all future liability. Does that answer your question?
Yes, ma'am. Thank you.
Yes. Does anyone else have any questions or clarifications at this point?
In case you do, there's a questions box in your panel. You can post your questions there and we'll take note.
Yeah, you can do that too, or just let me know by raising your hand and I can continue from there. So right now we're at a point where this whole situation, as you can imagine, is not good for anybody. It has not worked out well for the government. It has not worked out well for the victims. It's not worked out well for the families of the victims. And, you know, all in all, if you really take stock of what happened in Bhopal, it's a extreme embarrassment and a black mark for Indian legal system and Indian society in the last few decades. It's one of the worst things that's ever happened. Now I want to go into a quick analysis of why I think this happened and what could have been done to resolve it. Some of this is like basic economic legal analysis. You might counter some words which are unfamiliar. Please stop me at any point to get clarifications. Okay. So there is something called type 1 and type 2 error. Before I explain what that means intuitively, any one of you who's taken a basic statistics class would have encountered that type 1 error is rejecting a null hypothesis when the null hypothesis is actually true. In plain, simple English, we call it a false positive. And a type 2 error is not rejecting a null hypothesis when the alternate hypothesis is true. And we call that a false negative. So there are two types of errors that anyone can make, especially in these kind of legal cases. One is a false positive and a false negative. Now, what is a false positive and a false negative? If you see this picture up on the screen right now, a false positive is telling someone something when it's clearly not the correct information. So in the left-hand side, you can see that they are telling a man, you're pregnant, when we know for sure that that's not possible, at least not yet, not with the current technology we have. And a false negative is, if you look at the right-hand side of the screen, it's telling the woman who clearly looks pregnant, almost about to deliver, you're not pregnant. So there are two types of errors. One type of error is something that doesn't exist. We are convinced that that's true. And the second is something that is patently true. We think of it as false. Okay. So both types of errors were made in the Bhopal gas tragedy. So what does that mean in the Bhopal case? A false positive occurs in this type of accident case if the court or the bureaucrat imposes liability by mistake, right? Which means Union Carbide was made to pay for fake or spurious claims. That would be a false positive. That means, let's say someone like me, Shruti Rajagopalan, who was not born or wasn't around during the Bhopal gas tragedy in Bhopal, they say that, oh, she's filed for claim and she should get compensation. Now that's a false positive claim because I clearly wasn't there, but they are still giving me compensation as if I had a positive claim. A false negative claim is the opposite of this. It is someone who is a genuine victim and the court fails to impose liability. So let's say there is a genuine victim in Bhopal who has died or has been severely injured, but we don't recognize them as a victim, and that's a different type of mistake that you're making. So in the first kind of mistake, you are imposing more liability on Union Carbide and making them pay for fake claims. In the second type of error, you are not giving the genuine victims the correct amount of compensation. Okay. Now, what we see in Bhopal is you have both type 1 and type 2 errors. And the case I'm going to make in about the next 10 minutes is the reason for type 1 and type 2 error in litigation was because of the Bhopal Gas Leak Act, where the government decided to get rid of the ambulance chasers and represent all the victims all by themselves. So remember when I was talking about the ambulance chasers earlier on, sorry, I'm just trying to get that slide up for you. Yeah. So ambulance chasers are typically those who seek to encourage and profit from lawsuits of accidents, right? What does that mean? It means for an ambulance chaser, if the victim wins compensation, only then the ambulance chaser gets paid. But if the victim doesn't win compensation, the ambulance chaser doesn't get paid, right? This type of fees arrangement is called contingency fees arrangement or success fee arrangements. Contingency and success fee arrangements are not common in India because they're not allowed by the Bar Council of India, except in the cases of motor vehicles accidents. So you'll see that even in India, specifically in motor vehicle accident cases, where insurance companies and lawyers fight it out amongst themselves, and if the lawyer manages to win the case, then they get the commission, which is 33% typically, and if they don't win the case, they don't get paid anything. Okay, so now I want to bring this situation back to Bhopal, which is the contingency fee arrangement and how it can potentially avoid error. So let's say you have a contingency fees arrangements. What happens? If you have the ambulance chaser representing the victim, if the ambulance chaser manages to get money for the victim, only then he gets profits, right? If the victim loses money, then the ambulance chaser also loses money. This is called incentive compatibility. It means that the incentives of the ambulance chaser and the incentive of the victim are very closely aligned. So all those American lawyers who were disparagingly called ambulance chasers, they would have gotten compensation only if they got money for their victims. Now, it's true that they would have kept 33% for themselves and only 66% would have gone to the victims, but the money would have gone to the victims, otherwise even the lawyer does not get paid. And for every single victim that loses, the lawyer doesn't get paid at all, even if they spent money fighting the case. Which is, fixed amount fees or hourly fees. So what is the incentive alignment with these other arrangements? If there is a fixed fee, then whether the client wins or loses, the lawyer gets paid. This happens in certain types of cases. This typically happens in criminal cases. You can have hourly fees where if the client wins or loses quickly, then the lawyer gets paid very little. If the client takes a long time to win or lose, then the lawyer gets paid a lot. Now, as you can see, hourly fees is not a very good model because it may incentivize lawyers to drag out a case, right? So these are some of the different ways in which we can deal with legal fees. Contingency fees almost perfectly aligns the incentives of the victim and the lawyer, whereas fixed fee doesn't because the lawyer gets paid whether or not the victim wins. What about the welfare commissioner? You have a welfare commissioner who is a government bureaucrat who gets paid your standard government bureaucrat salary, pension, benefits, all of those things, fixed tenure, they don't lose their job. Whether a victim wins or loses a claim, it simply doesn't matter, right? The welfare commissioner is still getting paid. So if you look at what happened in Bhopal, there is a huge commission or an entire ministry dedicated to victims. All the people who work in that ministry are paid money every month, whereas the victims, most of them haven't even gotten compensation at the end of 31 years. And there have been no major protests saying we should sack the commissioner or we should dock their pay or we should only give them their retirement benefits or their pension when the victims get compensated, nothing like that. So welfare commissioner is going to get paid, all their incentives are completely misaligned with those of the victims. The next thing I'm going to move on to is what happens when you mix an adversarial system of litigation with this kind of inquisitorial system of evidence. So when you fight this out in court, both sides, both the victim and Union Carbide would have come and given evidence. Lawyers on both sides have a very strong incentive to uncover what the genuine information is. And I want to go into that a little bit. So let's say there is one particular victim. Let's say Abhinav is one of the victims of the Bhopal gas case, who is one of the conductors of the webinar. Now, Abhinav has a lawyer. Union Carbide has a lawyer. Abhinav's lawyer has a very strong incentive to show that Abhinav is genuine claimant of the case. Because if Abhinav is not a genuine claimant, then his lawyer is not even going to take on the case. Because if he doesn't win, then the lawyer doesn't get paid much money. So the lawyer already has a lot of incentive to uncover evidence that Abhinav is a genuine claimant. Union Carbide's lawyers will not get paid if they give into a lot of fake claims, right? Union Carbide's lawyers are also going to be paid based on how much money they save the company. So Union Carbide's lawyers have a huge incentive to provide all kinds of evidence to show whether Abhinav is a genuine claim or a fake claim. So they will bring about evidence saying that Abhinav's claims are not genuine, and Abhinav's lawyers will bring about the claim that they are genuine. And this kind of competitive production of evidence where both parties will undertake a detailed search for the facts and evidence is going to provide the best information to the judge. The Inquisition, on the other hand, has a monopoly model of evidence production. There is only one party producing evidence, no one else is. Second, all the evidence. India lawyers don't care. They have no skin in the game anymore. So the only people who are fighting are the victims, but the victims are not in a situation where they can go and present all the evidence. It's an inquisition where the welfare commissioner will unearth the evidence. So if you can imagine, all victims, fake and genuine, are going to present all kinds of paperwork, and now it's on the welfare commissioner to figure out which cases are real and which cases are not. Now, if the welfare commissioner pays some fake claims, he doesn't lose any of his own money. So he has no incentives to separate the genuine claims from the fake claims. His job is not linked to it. His money, his income, his profits, nothing is linked to that. So this adversarial system of litigation, which the Bhopal Gas Leak Act removed and instead put on this Bhopal Inquisition with the welfare commissioner, is the second reason we're not able to get the right information. So if you go back to type 1 and type 2 errors in an adversarial system, the defendant's lawyers have a lot of incentive to discover the faults in the plaintiff's lawyers, so they minimize type 1 errors, right, which is false positives. So Union Carbide's lawyers have a great incentive to get rid of spurious claims, reducing false positive errors. In a Bhopal Inquisition, there is no incentive. On the other hand, when it comes to type 2 errors, the plaintiff's lawyers, which is the victim's lawyers, have a great incentive to provide a lot of evidence of harm to reduce type 2 errors. The reason that they have a lot of incentive is they get paid only when the victim gets paid. So all your false negatives will decrease. So if you had a contingency fee system with ambulance chasers mixed with an adversarial system, you will get very few type 1 and type 2 errors, at least much less than what we have now. Compare this to the Bhopal Inquisition, there is no incentive to reduce type 1 or type 2 error. So what we've really figured out is that there is the original tragedy which happened because of all kinds of regulatory capture. Government of India didn't monitor Union Carbide carefully. The industrial inspectors of Government of India looked the other way when Union Carbide's plant was falling apart, so on and so forth. After the gas leak happened, the government completely failed. They didn't provide good emergency care. They didn't provide good medical care. They completely botched up the legal case, right? So we have a lot of government failure written all over the Bhopal gas leak situation. But one of the worst things that's happened, according to me, is that you have a system where you have, even once you've had a bad industrial disaster, you've had 31 years where, because of a particular type of paternalistic law, you've not managed to give the correct compensation. And the worst of it is, in the current system, there is no hope of ever figuring out the correct amount of compensation. It's simply not possible. As long as we continue with this inquisitorial system with Bhopal welfare commissioners, no one has any incentive to get any of this information right. And because no one has any incentive to figure this out, the victims are probably never going to get paid. So the only way to resolve this question would be to reopen the matter, allow for ambulance chasers to represent the victims, and even if the victims are only going to get 66% of the fees and the ambulance chasers will keep 33% with themselves, 66% is better than nothing, which is where the victims are right now. What we learn from this entire situation is, one, that incentives really matter and that the government has no incentives aligned with those of the victims. They've completely forgotten the Bhopal gas victims. The Attorney General has nothing to do with them. He's not an elected position. His future is not linked with the claims or futures of the victims. Second, one of the most important things is we need to understand which kind of legal processes, government and non-government, are going to lead to discovery of knowledge. Remember the original poster that said Sahi Akra, Sahi Muafza? This is a knowledge question. This is information we don't have, which we need to find out. So the question is, what kind of system do we need to have to figure out the correct information? And the government of India passing the Bhopal Gas Leak Act completely stopped us from getting the right information because it in some sense cut any access to the right information which would have come through ambulance chasers. Finally, the citizens of Bhopal would have really appreciated the initiative of the ambulance. What that means is you don't always, the question is not always about intentions, it's really about incentives. Ambulance chasers may not have had good intentions when it came to Bhopal gas victims. They just showed up from the United States and they tried to get as much compensation as they could. But the intention doesn't matter. They would have still managed to get more compensation for the victims because the incentives were very well aligned to do so. On the other hand, the government of India is very well intentioned in passing all this paternalist legislation, but because there is no incentive alignment, the good things which are supposed to happen don't happen. So when we look at these cases in the future, we really need to think about incentives and not about intentions. I'm going to wrap this up at this point right now, but I'm happy to answer any questions that you may have.
Hello. Yeah. I actually have a question. So the argument that you've been making with incentives.
Hang on one sec. I can't hear you, Shri.
Just a second. Is it better now?
Yeah, it's better.
So the argument that you've been making that incentives are more likely to give results, is it true that it's not just in the cases where such tragedies are concerned, but it will also apply to other areas, or is it just limited to, let's say, attesting liability to private sector, or cases where like not the government is involved, but private players are involved. So does this encompass every player in society, every institution, or is it just limited to private players?
I would say it is for every institution. You need good incentive compatibility. Let me give you another simple example of this, okay? Just to describe incentive compatibility. So in late 1700s, there was tremendous prison overcrowding in England. And because of the tremendous amount of prison overcrowding in England, they started shipping off prisoners to their other colonies, mainly Australia. So, as you know, there are a lot of these cases where we hear about how the first settlers in Australia were really convicts who were shipped over from England to Australia. Now, you can imagine that in the late 1700s, that was an incredibly long journey to go from England to Australia. It took many weeks. And there were these private Navy captains who would take prisoners on their ship and who would land them in Australia. And one of the things that we figured out was most people who made that journey, most of the prisoners died or they were severely diseased and they reached at varying levels of starvation on the other end. So let's say 100 prisoners left England, about 30% of them died on the way and another 30% of them reached in various levels of disease and starvation. Okay, so the numbers were pretty bad. A lot of people were protesting. If you look at British newspapers in the late 1700s, there were a lot of protests. There were calls for reform and legislation on prison overcrowding and shipping convicts to Australia. I think the person who came up with the solution to this problem must have been an economist because they made a very, very simple rule change. Earlier, all the private merchants who were taking taking prisoners to Australia, Shri, what happened to the mortality rates?
It probably decreased.
Do you know how much it
The
decreased?
practice was
You did.
99% of the I keep saying victims, I apologize. I'm still in Bhopal mode. 99% of the prisoners made it safely to the other end with a simple rule change, right? So what simple rule change do? It aligned the incentives of the sea captains with the incentives of society. So nothing happened. We didn't get new sea captains who were any less greedy, right? They were the same people running the same ships. The only thing that's changed is now you had to get people to the other side without killing them and without starving them, and only then you got paid. So in doing what was good for themselves, the sea captains also did what was good for society. And I'm making a very similar argument in the Bhopal case. Ambulance chasers within a particular institutional structure, in the process of doing something for themselves, in satisfying their own self-interest, they're actually doing something that's really good for society, which is making sure that we have the correct number of victims and that those victims get paid a lot of money to take care of their medical expenses, so on and so forth. What I'm saying on the other hand with the Bhopal welfare commissioners is, in doing what's good for themselves, they don't necessarily end up doing what's good for society. Their incentives are not aligned. I think you can apply this to pretty much any case. Good institutions are those which align incentives of the individual with incentives of society. So we can find a number of cases like this, where if you even look at a simple market case, right, you have a lot of companies which are selling pharmaceutical drugs which cure diseases and make sure that people, vast number of people don't die of simple diseases, which is completely avoidable. One argument is they're doing this to save humanity. Another argument is that the pharmaceutical companies just want to make profit. So they try and figure out diseases which are affecting very large numbers of people, and then they go and try and find cures for those diseases because that's where there's the most profit opportunity. So you can make this case for a lot of different types of things that you see in society.
Unmuted.
All right. I have another question, Shruti.
Yeah.
From your research, you might have like the government must have given some reasoning for why it decided to have a blanket ban on a private agency, a private representative representing the victims. So what was that reasoning? Why did they not allow the victims the choice to choose the government as a representative or a private law agency?
So it was really paternalism. We have a lot of paternalist laws in India where the state is constantly looking out for the welfare of the people. And very often when it's looking out for the welfare of the people, the arguments that they make is people don't know better. So their argument was Bhopal gas victims, a lot of them are poor, a lot of them are illiterate. They don't understand legal contracts that these sophisticated American lawyers are going to come and present before them. And so they're going to get fooled and hoodwinked by all these American lawyers who will take away 30, 35, 40% of their compensation. That's one part of it. So that was one main reason for it. The second main reason was they said, why should the American lawyers get 33% of our victims? Our victims should get the full amount, right? If you really think about it, that's a very well-meaning and well-intentioned argument. Unfortunately, they got the incentives completely wrong. And secondly, people are not that foolish. When you're trying to be paternalistic, every individual victim knows their circumstance, and the victims are not stupid. They want the best medical care for their family, or if they've lost any family member, then they want the highest amount of compensation. So to assume that these victims would be completely fooled by these sophisticated lawyers, I'm not so convinced about it. We have other ridiculous paternalist laws in India, like no one there are some laws in Delhi, I don't know if these are still in force, but this used to be the case a few years ago, that cycle rickshaw and auto rickshaw pullers, you can't own more than one, because then you become a thekedar and you are going to like extract high rents from cycle rickshaw pullers who will lease your vehicle, right? Now, this is to protect cycle rickshaw pullers. What ends up happening? There aren't enough cycle rickshaws and enough thekedars to lend them the cycle rickshaw, which means they need to buy their own cycle rickshaw, which requires a huge amount of capital. Which means someone who could have easily done the job of a cycle rickshaw puller can no longer do it because the regulation gets in the way. So you can think of thousands of paternalist regulations like this in India, some which are minor, some which are really problematic. And the Bhopal is a case of paternalism gone terribly, terribly wrong. But a few years ago, you have hand-pulled rickshaws in Calcutta, which many people think is very barbaric because a human being is literally pulling the rickshaw as opposed to using a cycle or a machine or a horse or some other animal. They wanted to ban that because they said it's against human dignity. And the people who were most upset about banning that was the hand rickshaw pullers. They said, don't try to protect us from our own livelihood. We want our source of livelihood. So very often in these well-meaning paternalist sort of regulations, the state really messes things up. So what we need to really look out for is not the well-intentioned paternalism, but whether the well-intentioned paternalism is also backed by good incentives.
Thanks for your answer, Shruti. We have a question from Saurya again. Saurya, could you go ahead and ask your question, please? Saurya, are you there? Or should I ask your question?
Yeah, can you hear me now?
Yeah,
I can hear you.
Yeah, I think I have a network problem. Just give me a minute.
Okay.
Yeah, hello.
Yeah.
Yeah, fine. Had India at that time had a better tort law jurisdiction, which should have allowed filing mass tort cases and all, similar to what happens in USA, would that have changed the scenario in any case?
Yes. But even without a mass tort system, see, we like to think as if these systems existed before the tragedies, right? How do mass tort systems develop in other countries? Post-industrial revolution, you've had a huge rise of industry and therefore of industrial accidents. As industrial accidents increase and therefore personal injuries increase, the mass tort system develops to support that kind of industrial system. We simply didn't allow that to happen in India. I think if we had allowed the Bhopal litigation to take place in India using individual lawyers, you would see class action tort today in India. And class action tort is not a top-down approach. I mean, if you think about it in the United States, it's not that different. You have procedures for it, but it's not like the legal system needs to morph itself in any way. What really needs to happen is you need to have law firms which specialize in a particular kind of personal injury, and they are able to take on a large number of victims and represent them at the same time, right? We simply don't allow that in India. The Bar Council of India doesn't allow for contingency fees because they think lawyers should fight for justice and not for money, right? You have instances like the government of India passing laws like the Bhopal Gas Leak Act, where they are preventing lawyers from specializing in personal injury or class action tort. So what's really happened in India is we haven't been given a chance to develop that kind of a legal system. Because the legal system is not just courts and judges. The legal system is also having specialization amongst lawyers to take on those kind of cases. And you will have specialization in lawyers. Like India didn't have motor vehicle injury specialists about 85 years ago because not so many Indians entered motor vehicle accidents, right? Today we have special courts for this. You have lawyers that almost entirely specialize in getting compensation for motor vehicle injuries. So as the system develops, lawyers find profit opportunities like any other businessman or entrepreneur, and they develop that system. So to answer your question, if India had had a better tort law class action system, would this have happened? No. But on the other hand, India doesn't have a better tort law system because they didn't let it. It's a bit of both. And the second way to answer that question is, what has happened in India is because they haven't allowed individual private people to have class action tort. In India, public interest litigation is really the class action tort of India, right? Any environmental disaster that happens, we have thousands of victims being represented in a public interest litigation, which is much more inefficient than the class action tort that we have. Because here a lot of the victims are unknown, they're nameless, they're faceless, it's very hard to get them compensation even in a PIL. So the PIL in some sense has been crowding out private tort litigation. So I would say it's a mix of these two or three different things. Saurya, does that answer your question?
Yeah, thank you.
We have, I think Aishwarya Rajgopalan has raised her hand. I'm wondering if she has a question. Aishwarya, do you have a question or do you have something to say? I have,
Hello.
yeah, I have one.
I must hear from another Rajgopalan, so go for it.
Yeah, I have a question. So, even though all of this sounds really absurd, and I'm sure the government doesn't justify things like passing these laws, and how, like, is there any way to go around something like what happened in 2005? As a reply to an RTI query, the Ministry of External Affairs exempted any information about this tragedy to be available to anybody.
Can you say that again?
So how do we work around this? Hello?
Yeah, I think I missed bits of what you're saying. Can you say that again?
So I was saying in 2005,
Yeah.
The government passed an act under the RTI which exempted any information about the Bhopal gas tragedy from being given out.
Yeah.
So is there any law which can help us out here, and what is the justification to this? And how do they
say that again? And how do they? Aishwarya, I think I'm losing you. Can you say the last part again?
The last part? Hello? Can you hear me?
Yeah. You said, is there any justification and how do they? And after I lost you.
Yeah, is there any justification to this, A? And B, is there any law which helps us as citizens to find a way around this?
That's a really good question. And I don't know if I'm going to give you a really good answer for it. The Bhopal, so when the government of India was entering into entering into an agreement with Union Carbide, it was doing so under its sovereign function, which is very hard to challenge. So in Charanlal Sahu, they tried to challenge that. They tried to challenge on 2-3 grounds. One of them was parens patriae, which means like the government acts like it's the parent of the citizens, right? It's an old British rule where the king is supposed to act as if his subjects are his children. So they tried to challenge that, and it's very, very, very difficult to get through challenges when the challenge is about the sovereign function. The other challenge to this particular case in Charanlal Sahu was that there's a conflict of interest with the government. If you notice, Union Carbide India Limited is a government-owned subsidiary, right? So government is part owner of the firm where the gas leaked, and the other part owner is Union Carbide. So 51% of UCIL was owned by the government. So one of the challenges was that this is a tremendous conflict of interest where how can the government be a party where it's also the defendant in a case, right? And that challenge also went nowhere. The third was on the grounds of natural justice, which is how can you not let people represent themselves? It's one of the most fundamental rights. That argument also went nowhere. I think it's the reason for it is a couple of things. One is when there is immense crisis, arguments that normally make rational sense just fly out of the window because everyone is trying to make special exceptions to take care of the victims at that time, right? So normally rules which sound completely absurd in peacetime or when there is no crisis they suddenly start making sense because you're like, oh, we're in crisis mode. There's this tremendous accident that's happened. We need to give the government all the power that we can possibly give them. So that's one type of argument. The other is simply it's very difficult to get around any argument made where the government is exercising its sovereign function. And there are a lot of exceptions to RTI, like defense, like security, classified information, any information where relating to an international treaty, so on and so forth. Because this case was so international in nature, I don't know the exact details of the justification they used, but I'm guessing it'll be under one of these things, that we simply, citizens should not know the dealings that they had with foreign governments. I think all of it is nonsense. I agree with you. It's totally absurd. But that would be my guess. I think that's the kind of argument that they would make. We just need to fight back more, either through RTI or through courts or through challenges or through protests supporting Bhopal victims. Like, there has to be a way to get around this. But more important than what happened in Bhopal, remember, we're in a country where we're growing at a fast pace. We will have more industrial accidents in the future. So the biggest learning you can get from Bhopal is what do you do the next time this happens? And hopefully the next time something bad happens, we hope nothing bad happens, but the next time something like this happens, you don't get into this kind of a paternalist regulation mode that destroys and distorts all kinds of incentives. I don't know if that's a satisfactory answer to your question, but that would be my best shot at it.
Well, you can't give a satisfactory answer to something like this, like when you said there has been a conflict of interest. But I think what you said makes a lot of sense, yes.
Yeah, I hope so. But this is a tough one. Like, this is a tough case. And the even more curious part, when I first started writing about Bhopal, to me, I mean, probably because I have a law and economics background, to me the case was entirely about compensation and type 1 and type 2 error. When I started digging on who's written about this, I noticed that no one has written about the Bhopal Gas Claim Act other than constitutional issues. So even people who thought that the whole thing was terrible, and even people who think that the government completely botched it up and, there should have been a better solution out there, even those critics say the Bhopal gas leak was a good idea, the act. They're like, no, India simply isn't a country where we could have left it to profit-making lawyers. They would have completely hoodwinked the victims. So the real solution was this Bhopal Gas Leak Act. The intention behind it was very good. It was totally workable. It was just bad execution. That's a typical sort of argument made for all kinds of Indian government botch-ups. Everyone says, oh, it's a very good idea, but the execution failed. Next time we should execute it better, right? I think differently. I think this could not have been executed better under the given system of government regulation, because that regulation completely distorts any incentive for getting it right. So that would be, the big learning from this. But pretty much no legal scholar has written about this, which to me, personally, I find that quite incredible. But after 30 years, I wrote my paper last year, and I really dug deep. I tried to find who else has critiqued this law. There's very little criticism of the Bhopal Gas Leak Act. There's criticism of Union Carbide, there's criticism of Dow Jones, which bought over Union Carbide, criticism of government of United States, which refused to extradite some of the top leadership of Union Carbide, criticism against the government, against Attorney General of India for getting the numbers wrong, but no criticism of the thing that set all of this in motion, which is this paternalist law. So I think those, going into the future, if any of you are working on these issues, I think that's the kind of stuff we need to spot early on to prevent this kind of a legal disaster.
All right.
I see lots of.
Yep. We have. I think Saurya had raised his hand. Aishwarya's hand is still up. I'm going to unmute her if she has something to say. But nobody else, I guess.
Oh no, I need to lower it. Sorry.
All right. Yep. I guess. Okay. Saurya has indeed raised his hand.
Okay, Saurya. Go for it.
Yeah, hi. Yeah, one last question.
No,
Like,
ask
as
as
far
many
as
as you.
no, no, as far as I recollect, the compensation which was collected on behalf of the victims, it was the
Yeah.
entire amount has still not been disbursed. A part of it is still lying in RBI, unused,
Yes.
untouched.
Yes.
Right.
Yes.
So technically, if the rest of the amount, like it stated earlier, was supposed to have been paid by the government, taking it
Yeah.
from tax money, instead of having taken it from tax money, couldn't that amount be invested, the one which is lying in RBI right now? Because
I think they weren't allowed to invest it. I think the whole point was if you invested, you risk losing money, but you also risk making money. So you don't want to mess with the corpus of the compensation. However, even without investing, it has collected a tremendous amount of interest over 30 years. So there's a lot of money to be given. But remember, the problem is not just the money. The problem is we have no system to figure out who to give the money to and how much money we owe them, right? That information is not readily available. We pretended to conduct the entire Bhopal proceedings as if we know who the victim is and how much money they are supposed to get. But that information needs to be discovered. We have no discovery mechanism. So let's assume that the money, because it's collected so much interest in the RBI account, is enough, right? We still don't know who to pay how much to. Now let's assume it's not enough and the government needs to make up the shortfall, okay? Let's say, okay, the taxpayers bite the bullet because, we screwed up, we made a mistake with Bhopal, but Bhopal citizens are Indian citizens, so let's give them the money. So let's say the taxpayers are also on board with it, right? We still don't know who to give the money to and how much money we owe them. So there's something broken in the system, which is a different question from the existence of the compensation and whether the money is enough. So yes, you're right. I mean, we could have invested it and made more money that would sit in the bank account.
yeah,
That's
but
doable, but
yeah,
it
but as
does
long as, like you said, we don't know who to give the money to, there's no point having the money.
exactly. So it doesn't solve the more immediate problem. So one part of the problem is the resource constraint. That is one argument. We asked for too little money and we absolved Union Carbide of all past, present, future. So we should have asked for more money. But let's say we have more money, we still don't know what to do with it. As
True.
of today, I don't think there'll be many Indians who say, you know what, Government of India screwed up 30 years ago, Indian taxpayers are not going to pay them compensation. Let's say there is a 75% shortfall. Indian taxpayers will still rally around and say, you know what, Bhopal victims deserve justice. It's not ideal, but I don't think there'll be too many naysayers. So let's say we cover the shortfall. We still can't get it right because the system is broken in a way that we can't get it right. So if you ask me what needs to be done in the future, I would say the following. We need to get rid of this inquisition by Bhopal Welfare Commissioner. We should allow victims to have lawyers who will take 1/3 of the uh, compensation, and then they'll get it right. Even now, it's not too late. We can still have some kind of a half-baked solution to get it right. It won't be a perfect solution, but it'll be better than what we have now.
All right.
Agreed. Understood. Thank you.
Um, guys, any more questions? All right. I guess we can call it a wrap. Shruti, you could probably introduce your paper before we leave, and then we could. Uh,
Yeah, I'm just going to put this up, and the SFL guys will find a way to get this to you. Uh, I'll just put this up online. Hang on a sec. Uh, I wrote this paper for Journal of Indian Law and Society last year. It's called Bhopal Gas Tragedy, Paternalism and Filicide. Paternalism, you all know what it means. It's looking after the citizens as if the government is the parent, and filicide is killing your own children. So I think Bhopal Gas Tragedy is a classic case of paternalism gone terribly wrong. And I make the main argument that I've already worked out for you guys, but the paper has a lot more detail about exactly what happened in Bhopal because it's hard to convey all of that in like 45 to 50 minutes. So if you want to dig deeper in this case, find out what really happened, and especially if you want a lot of references on what to read, a lot of it will be in the paper. It's not too long and it's not at all technical. So if you're interested in this topic, please go ahead, read it, and you can email me if you have any questions.
All right. Thanks a lot, Shruti. Thanks for doing this webinar for us. This went really well. This went, and it's going to be recorded. It's going to be put up on the website, and I hope a lot more people are going to watch it in the future. Thanks a lot.
It was my pleasure. Thanks so much for listening. Good night, guys.
All right. Thanks everyone for joining us, and hopefully you'll attend the future webinars as well. Thanks a lot.